Roll it all the way down for me, please.
If you're watching this on body cam footage, you're about to see something that happens in thousands of traffic stops every single day. The officer walks up to the driver's window, and before he even says hello, he's already looking at the gap between the glass and the door frame. Then he says it, "Sir, roll your window all the way down." And right there, in that split second, you have to decide what to do. Because if you get this wrong, you might just turn a simple warning into a full-blown vehicle search. My name is Steve. I've been a criminal defense lawyer for over 20 years. And today, I'm going to walk you through a real illustrative traffic stop caught on Dashcam where that one sentence changed everything. The footage shows a sedan, silver, pulled over on a two-lane road just after dusk. The officer keys his mic. "I'm out with a 1048, possible window tint violation." He approaches the driver's side, and the window is down about 5 inches. Enough to talk? Enough to pass a license through. The driver, a guy in his late 20s, already has his hands on the wheel. Calm. Compliant. The officer doesn't ask for his license. Instead, he taps the glass with 2 fingers and says, "Roll it all the way down for me, please." Now, most people think, well, I have to. He's a cop. It's his stop. I don't want to look like I'm hiding something. And that gut instinct is exactly what law enforcement counts on. Because here's the thing. Rolling that window down the rest of the way isn't just a courtesy. It's a tactical move that turns a partially enclosed vehicle into a wide-open observation platform. Let's break down what's really happening from both sides of that glass. On the officer's side, there's a legitimate safety concern. The Supreme Court has recognized over and over that traffic stops are inherently dangerous for officers. The moment the window goes all the way down, an officer can see your hands, your lap, the passenger compartment, anything in plain view that might be a weapon or contraband. But there's a second reason, one that rarely gets stated out loud: scent. With the window fully retracted, the officer can smell what's inside that car. Burnt cannabis, alcohol, raw marijuana, even if they didn't have probable cause before the stop. And in many states, the odor of marijuana, whether legal or not for recreational use, still provides the basis for a warrantless search. So that request to roll the window down is also an olfactory opening. On your side, you have a Fourth Amendment right to be free from unreasonable searches. But this isn't a search yet. It's a command during a lawful seizure. So the legal question isn't, can they ask? They can ask for just about anything. What happens if I don't comply? And what rights do I actually have? And that's where a handful of Supreme Court decisions create a tightrope that every driver should know about. First, let's talk about the order itself. A police officer conducting a traffic stop has the authority to control the movements of the driver and any occupants. In Pennsylvania v. Mims back in 1977, the court said that once a vehicle is lawfully stopped, ordering the driver out of the car is a reasonable, minimal intrusion that doesn't require any additional suspicion. In Maryland v. Wilson in 1997, that rule was extended to passengers. Now, neither of those cases dealt with window position directly, but they established a principle. Officers can take steps to ensure their own safety during a stop, and those steps can include controlling your immediate environment. The 11th Circuit in United States v. Brown later dealt with a situation where an officer ordered a driver to roll down a heavily tinted window, and the court held that because the officer had reasonable suspicions of a window tint violation, ordering the window down was a reasonable safety measure. It allowed the officer to see inside the vehicle and monitor movement. So if your window is already partially down but the officer says all the way, a court will likely evaluate that under the same safety rationale especially if there's a tint issue, nighttime conditions, or furtive movement. But here's where the myth gets busted. A lot of people believe that if an officer says roll it down, you have to, and if you don't, you're automatically obstructing. That's not quite true. There's no statute that criminalizes keeping your window partially up, unless you're in a state with a specific law about obstructing an officer's view, and even those typically require an element of active concealment or refusal to provide identification. What you do have is the right to ask a clarifying question, and that's the pivot point in our dashcam footage tonight. In the video, you can hear the driver respond. "Officer, I'm comfortable at 5 inches. Is there a specific safety reason you need it all the way down?" The officer's posture changes immediately. He straightens up, leans back a half step. Because that question tells him 2 things. 1, this person knows he doesn't have to blindly obey every command. And 2, the driver just put the burden back on the officer to articulate a reason. That's the exact phrase I want you to remember from this video. Write it down, say it out loud a few times, because it will feel unnatural in the moment. "Officer, I'm comfortable with this much. Is there a specific safety concern you can tell me about?" That's it. You're not refusing. You're not being combative. You're asking for a verbalized basis. And here's why that matters. If the officer can't articulate a safety reason, or worse, says something like, "because I said so," and then escalates to a search or a frisk based on what he sees or smells after you comply, a good defense attorney is going to challenge whether that escalation was consensual or a product of an unlawful extension of the stop. Remember Rodriguez v. United States in 2015? The court held that a traffic stop cannot be prolonged beyond the time reasonably required to complete the mission of the stop, addressing the violation and issuing a ticket without independent, reasonable suspicion. So if the sole reason for demanding a fully rolled down window is to create an opportunity for a fishing expedition, and you can get the officer to admit that on body cam, you've just built part of your suppression motion. Now let's rewind the dash cam and see what happened to the silver sedan. After the driver asked that question, the officer paused. Body cam audio picks up a faint radio crackle. Then the officer says, "It's just safer if I can see your hands and your lap clearly." The driver, still calm, still hands on the wheel, says, "My hands are right here on the wheel. You can see them through the opening. I don't consent to any searches, but I'm going to put them back on the wheel now." And he did. The officer didn't like it. You could see the tension in his jaw, even through the grainy dashcam footage. He called for backup. 2 minutes later, a second unit arrives. Now there's a conversation happening between the 2 officers on the side of the road, off mic mostly, but you can see the gestures. One points to the window, the other shrugs. Then the original officer walks back, asks for license and registration, and the driver provides them through the 5-inch gap. No sudden movements. No delay in producing documents. What started as a potential suspicion of a window tint violation, which, by the way, was never tested with a meter on scene, just turned into a standoff about compliance. Now, I've seen this scenario play out in courtrooms across the country. The officer later writes in his report that the driver was nervous, confrontational, and refused to comply with a lawful order. The driver? He walks away with no ticket because the tint wasn't actually illegal in that jurisdiction. And the stop ended after 22 minutes with no citation, no arrest, just a verbal warning about next time rolling the window down. But that outcome only happened because the driver knew the line between cooperation and waiver. Let's pull that line into sharper focus. When you roll your window all the way down without question, you're not just being polite, you're eliminating any physical barrier between the officer's senses and the interior of your car. Plain view doctrine says that if an officer is lawfully positioned and sees something incriminating, a gun, a baggie, an open container, That's probable cause for a search, no warrant needed. So by creating a full aperture, you're inviting a visual inspection of areas that might otherwise require a warrant to access. It's not illegal to do that, but it's also not required. You're free to protect your privacy as long as you don't actively obstruct a legitimate safety measure. The second major risk is the scent window. I've represented clients where the entire probable cause affidavit rested on the officer saying, "I smelled the odor of burnt marijuana emanating from the vehicle." And what did the officer do immediately before that? Ask the driver to roll down the partially tinted windows. Even in states where cannabis is legal, the odor of cannabis in a vehicle can still be used to justify a search under the motor vehicle exception, because driving under the influence or having an open container of cannabis in the passenger compartment remains illegal. So that simple act of rolling a window down can become the domino that topples your entire privacy interest in the vehicle. Now, if you think the solution is to keep the window completely up, that's a different mistake. If an officer knocks on glass and you refuse to lower it at all, you're likely violating laws that require you to provide identification and interact with law enforcement during a lawful stop. A completely closed window can be seen as creating a safety barrier, and courts are very deferential to officer safety. The sweet spot, the prudent middle ground, is exactly what our driver did. Leave enough of an opening to communicate, to pass documents, to breathe, but not so much that you're converting your car into an open-air exhibit hall. And if you're asked to lower it more, ask why. Let's ground this in a real case that illustrates the limits of an officer's authority to order a window down. In United States v. Stanfield, from the Fourth Circuit in 1996, an officer stopped a vehicle with heavily tinted windows. He ordered the driver to roll down the window, and when the driver complied, the officer saw a gun in plain view. The court found the window roll-down order was reasonable because the tint made it impossible for the officer to see inside, a genuine safety concern. But in United States v. Ruidiaz, the First Circuit in 2008 scrutinized an order to roll down a window where there was no tint issue and the driver's hands were visible. While the case turned on other factors, the court noted that the degree of intrusion matters, and that a demand to fully roll down a window is not automatically reasonable without a safety or investigative purpose. So context is everything. Tint level, time of day, visible movement inside the vehicle, the officer's demeanor, all these things matter. Back to our dashcam story. After the backup arrived and the documents were handed over, you'll notice something subtle in the footage. The second officer walks to the passenger side, shines a flashlight through the 5-inch opening, and then walks back, shaking his head. Nothing. No contraband. No weapon. No scent. The original officer returns the license, says, "Have a good night, and please fix that window tint," and the stop ends. No arrest, no citation. The driver slowly pulls away, and the dashcam shows the officer standing there for a solid 10 seconds, hands on his hips, clearly frustrated. That frustration? It's not because the driver was guilty. It's because the driver maintained his constitutional boundaries politely and firmly, and the officer knew he had no grounds to go further. That is the power of knowing the law. So let's distill this into 3 practical takeaways you can use tonight. First, during any traffic stop, keep your hands visible and your window partially open. 4 to 5 inches is plenty. Second, if you're asked to roll it all the way down, use that exact phrase. "Officer, I'm comfortable with this much. Is there a specific safety concern you can tell me about?" The tone should be calm, not confrontational. You're asking for information, not challenging authority. Third, if the officer articulates a legitimate safety reason, like, "I can't see your right hand behind the door panel," then comply immediately. A genuine safety command based on an articulable fact is different from a generic demand. Your rights are strongest when you can distinguish between the two. And never, ever lie or physically resist. That turns a Fourth Amendment debate into a trip to jail for obstruction. Your protection is in your words, not in your force. Now you might be wondering, what about the passenger side? Can an officer demand the passenger's window be rolled down? In general, the principles of Maryland v. Wilson apply. If the officer can articulate a safety need, a court may allow it. But the same response works. If you're the passenger, you're under no obligation to roll down your window beyond what's necessary for the officer's safety. Politely asking for the safety reason still works. And what happens if the officer then says, "If you don't roll it down, I'm going to order you out of the car"? That's where MIMS takes over. The officer can order you out of the vehicle for any reason or no reason at all during a lawful stop. So if the goal is just to keep the window partially up to protect your privacy, be aware that the officer may escalate to an exit order, which then exposes the entire interior of the car to plain view anyway. That doesn't mean you shouldn't assert your right. It just means you need to understand the whole chessboard. One final piece of legal context. The Supreme Court has never directly ruled on whether a driver must roll a window fully down upon requests, but the cumulative weight of the vehicle stop cases points toward a balancing test. The government's interest in officer safety versus the intrusion on the individual's privacy. In Berkemer v. McCarty, the court acknowledged that a traffic stop is a seizure under the Fourth Amendment, but a limited one. In Terry v. Ohio, the standard for a frisk requires reasonable suspicion that the person is armed and dangerous. So if rolling a window down is a demand that has no clear safety justification and appears designed to create a plain view or olfactory opening, it starts to look less like a safety measure and more like a search without cause. And that's the argument your lawyer makes at a suppression hearing, using the body cam footage and your calm, recorded words to show the judge that this was a fishing expedition. So, next time an officer taps your glass and says, "Roll your window all the way down," you're not going to panic. You're going to know exactly what's at stake, exactly what to say, and exactly how to protect your rights without creating a problem. Because the difference between a warning and a search is often just a few inches of glass. Now imagine this same stop, but the officer doesn't ask about the window at all. Instead, he asks you to step out of the car right away. Does your answer change? That's a whole different balancing act, and it's one we'll break down next.